namin pagtanghali,
We
boss.
need coffee.
Sure, but not just any coffee. Dapat kung sobrang sarap na kape. Coffee ko brown.
Coffee ko brown. Presence of Hontiveros. The presence of the chair is President from the on record.
Ito yung mga record.
Recording in progress. Progress.
The National Task Force for Against Professional Squatters and Squatting Syndicates, and also the Anti-Illegal Real Estate. We have been talking to our regional director for establish professional squatters incidences of anti-legal real estate.
And for the
As
guidance
far
of the
po
committee,
as
we adopt the
regulation
rules of the Senate
of
and the Senate Rules of Procedure governing
there's
committees in aid of
developers that
legislation to
issued
govern our proceedings.
certificates of
And my
registration
colleagues
and
will
licenses to sell
be
for establish incidences of monitor
And for the
as
guidance
far po CRLS nalaman po na nagbibenta po ang mga tao na hindi naman po issuean ng license to sell for issuance of registration and license ginagawa ang mali mag-issue na po kayo na nalaman po na nagbibenta po ang mga tao na hindi naman po issuean ng license to sell for issuance
Nangyari, hindi na refund. Hindi nyo na kaya, sa programa ko na kaya. Ito yan. Give you some examples. I'll show you.
Senator Hontiveros. After which we will be tackling Revised Government Auditing Act, Senate Bill 247 by Senator Villanueva, Senate Bill 502 by Senator Escudero, and Senate Bill 868 by Senator Estrada. Before we proceed, again, we place on record the presence of Senator Risa Hontiveros. May we now request our Committee Secretary, Attorney Ethel Hope Dignadice Villaflor, to put on record and acknowledge our resource persons. Go ahead,
Thank you, Mr. Chairman.
Villaflor.
I would like to acknowledge the following resource persons.
Sorry,
Okay.
go ahead.
For the revised labor law, from the Department of Labor and Employment, Yusek Felipe M. N. Escargo Jr., ASEC Adeline De Castro, Attorney Alvin Curada, Attorney Juvan Ray Narisma, Mediator Arbiter, Bureau of Labor Relations, Director Patrick Patri Wirawan Jr., Bureau of Local Employment, Executive Director Maria Crizelda C. from the National Wages and Productivity Commission, Ms. Teresita Audea, Deputy Executive Director, National Conciliation and Mediation Board. Attorney Hernan Nicdao, Commissioner, National Labor Relations Commission. Engineer Jose Batino, Executive Director, Occupational Safety and Health Center. Director Lorraine Judith Marie Giovanani from TESDA Enterprise-Based Education and Training Office. From the Governance Commission for GOCCs, we have Chairperson Attorney Marius P. Corpus and Commissioner Geraldine Marie Berberabe Martinez. From the University of the Philippines, we have Attorney Arnold De Vera, Program Director, Attorney Nathaniel Diaz, Senior Legal Associate, Professor Patricia Salvador Dayao, Founding Program Director, Workers and Employees Program, and Attorney Jasper Frederick Briones, Junior Legal Associate, Workers and Employees Program. From Partido ng Manggagawa, we have Mr. Renato Magtubo, Chairman. National Anti-Poverty Commission, Formal Labor and Migrants Workers Sector Council, we have Mr. Danilo Lacerna, Sectoral Representative. For the resource persons, for the revised Government Auditing Act, we have Commissioner Douglas Michael Malilin from the Commission on Audit. Also from Commission on Audit, we have Assistant Commissioner Brasilio Sabaldan, Assistant Commissioner Alejandro Juliano, Assistant Commissioner Nilda Plaras, Assistant Commissioner Martha Roxana Sese, Assistant Commissioner Roy Ursal, Assistant Commissioner Lorna Cabuchan, Assistant Commissioner Joel Estolatan, Assistant Commissioner Estela Mercado, Director Heidi Espuelas, Director Ramel Sumingit, Director Roberto Mabagos Jr., and Director Erwin Lapitan. From the Department of Information and Communication Technology, DICT, we have Yusek David Almirol Jr., Undersecretary for E-Government. From the Government Corporate Counsel Office, we have Attorney Owen Vidad, Legal. From the Office of the Solicitor General, we have Attorney Maria Rita Cecilia De Leon Abad, Senior State Solicitor. From the Philippine Institute of Certified Public Accountants, PICPA, we have Attorney Aristeo Cruz, Chairperson, Committee on Legislation, Accountancy Law, Bylaws, and Article Review. Attorney Rin Sikban, Member, Committee on Legislation, Accountancy Law, Bylaws, and Article Review, and Attorney Adora Santos. From Public-Private Partnership Center, we have Attorney Phoebe Bell Ramos Lacuna. That's all, Mr. Chairman.
Thank you to our committee secretary. We now proceed with the opening statements of our members of the panel. I begin with my opening statement. Magandang umaga po sa ating lahat. Salamat sa inyong pagdalo sa public hearing na ito. Sa gitna ng sigalot, sa gitna ng silangan at sa pagtaas ng presyo ng petrolyo, meron tayong dalawang malaking paksa na tatalakayin ngayong umaga. Parehong ipinanganak noong 1970s. Marapat na suriin kung nararapat na bang may pagbabago sa labor code at sa ating audit code. Marami nang nagbago at patuloy na nagbabago sa mundo na nagbabanta sa kagalingan at karapatan ng mga manggagawang Pilipino. Ang panukalang revised labor code ay para sa milyong-milyong manggagawang kababayan natin. Bukod sa kinikilala nito ang malaking pagbabago sa mundo, inipon din nito ang lahat ng mga hiwa-hiwalay na Supreme Court ruling na naka-align sa ating mga international commitment para sa karapatang pantao, pagkakapantay-pantay ng kasarian at disenteng trabaho. Isinama rin dito ang mas bago pang mga pambansang proteksyon para sa mga overseas Filipino workers, kababaihan, PWD, at mga manggagawang nasa non-traditional arrangements tulad ng mga gawaing dulot ng mga apps at GIG, gig labor. Kung walang updated na labor code, haharap ang ating mga manggagawa sa iba't ibang pagyanig ng luma na mga panangga o proteksyon. The proposed revised labor code makes workers' rights easier to understand, easier to claim, and easier to enforce. Ang pangalawang paksa ay malapit pa rin sa puso ng mga kababayan nating lumalaban ng patas. Sa lahat ng iskandalo sa pananalapi, ghost at overpriced flood control projects, substandard laptop at fertilizer scams, hoarding at smuggling ng agri-products, at inabusong confidential at intelligence funds, gusto rin nating bigyan ng angkop at makabagong kasangkapan ang Commission on Audit so that COA can follow the money. Halos kalahating siglo na ang ating audit code. Isinulat sa panahon ng typewriter, snowflake, paper ledger, at simpleng agency-to-agency transactions. Government has since moved into a digital, public-private partnership-driven, off-budget world, while COA is still expected to police 21st century corruption and other anomalous transactions with a 1978 playbook. Isa lang ang gustong gawin ng tatlong panukalang batas ng Senate Bills 868, 502, and 247 respectively. Dalhin sa bagong siglo ang Government Auditing Code nang sa gayon ay may jurisdiction ng COA na sundan ang daloy ng pera ng bayan sa mga pribadong kumpanya at pati public utilities. Simpleng panuntunan, sino man ang tatanggap, mamamahala o magbebenepisyo sa pera ng bayan, bukas dapat sa public audit. Mahalaga ito sa taong bayan. A modernized code strengthens COA's power to disallow irregular spending, recover lost funds, and pierce the veil of so-called private implementers in the many corruption scandals that have plagued the country. In the fiscal year, 2026 GAA, we already required all government agencies, including GOCCs and LGUs, to support the Commission on Audit's Citizen Participatory Audit Program. This provision of the Audit Code goes further by institutionalizing the participation of civil society in the conduct of audits. In this way, governance is no longer done only for the people, but with the people. Sa huli, gusto lang nating protektahan ang karaniwang manggagawa, ang mga wealth creators sa kanilang trabaho at protektahan sila laban sa katiwalian. Ibigay natin ang deserve ng sambayanang Pilipino, matino at maayos na pamunuan. Maraming salamat. We now give the floor to Senator Risa Hontiveros for her opening statement.
Salamat Mr. Chair at magandang umaga po sa inyong lahat. Salamat sa ating Chair, Senator Kiko, at sa ating labor law practitioners mula gobyerno, akademya, labor at management sectors at progressive and alternative lawyers from UP Diliman na nagsika para sa pag-amyenda ng Labor Code of the Philippines. Gaya ng sinabi ni Chair, mahigit 50 taon na ang ating labor code. Malaki na nga ang nagbago sa ating ekonomiya, sa paraan ng pagtatrabaho at sa hamon na hinaharap ng manggagawa. Meron ng contractual work, subcontracting, freelancing, platform-based jobs, online work, and the gig economy. Nariyan din ang epekto ng digmaan, pandemya, rise of AI, pagtaas ng presyo ng krudo at iba pang issue. It is time for our labor laws to catch up. Kailangan palakasin ang labor code at ipatupad ang sistematikong reforma na hinihingi ng manggagawa, gaya ng nirereklamong provincial rate para sa daily minimum wage. The updated labor code should integrate international labor standards and plug policy gaps in worker protections, including those addressed by jurisprudence and executive issuances. Dapat ding isynchronize ang labor code sa mga bagong batas para sa manggagawa gaya ng expanded maternity leave law, expanded solo parents welfare law, Anti-Pogo Act at iba pa, at alisin ang diskriminasyon ayon sa relihiyon at kasarian. Oras na para ayusin ang framework ukol sa pagdinig sa labor disputes at labor violations gaya ng illegal dismissal at unfair labor practices. The snail-like resolution of thousands of labor cases which helps perpetuate labor injustices must end. Umaasa ako na sa tulong ng pagdinig ngayong umaga, magkakaroon tayo ng epektibong revised labor code na tutugon sa pangangailangan ng manggagawa, ng employers at ng ating ekonomiya. Salamat po.
Thank you very much. We can now proceed. Again, as earlier manifested, we will start with the revised labor code proposals. I understand the Dole has a presentation as well as the UP Law Center. May we request that the resource persons limit their given the number of resource persons, to limit your presentation to 3 to 5 minutes, and if necessary, request for a 2-minute extension. We can now proceed with Dole. You have the floor, Yusek Felipe Egargo Jr.
Thank you, Mr. Chair. Honorable Chairperson, honorable members of the Committee on Constitutional Amendments.
Before you proceed, sorry, the chair recognizes the presence of Senator Rafi Tulfo. Do you have an opening statement, sir?
Yes, Mr. Chair.
Yes, we will request para tuloy-tuloy na, no? We will request Senator Rafi to proceed with his opening statement.
Good morning, Mr. Chair, Senator Kiko Pangilinan, and to our resource persons and guests for today's hearing, and Senator Risa Hontiveros. I thank this committee for taking up the much-needed revision of two important codes which are vital to our legal system: the Audit Code and the Labor Code, two sets of laws which are more than 40 years old. Mas bata pa tayo kaysa sa mga kudal na ito. First, I fully support the proposed revision of the Government Audit Code of the Philippines. In particular, I welcome the expansion of the Commission on Audit's authority over private entities managing public funds. For the first 3 years, ilang beses ko nang konesyon ang legal personality ng PEA, or the Private Education Assistance Committee. As the entity authorized to manage school subsidies under the e-GASPE law, dati na itong na-flag ng COA for its stern refusal to be audited sa katwirang isa daw siyang private entity sa kabila ng kawalan ng SEC papers. Thanks to a Supreme Court ruling which finally and categorically pronounced those private entities such as PEA should be audited by COA for as long as they manage public funds like e-GASPE subsidies. Cementing this ruling of the Supreme Court into our audit code will certainly make things clearer as to who can and cannot be audited by COA. At dito mas mapalakas ang kakayanan ng COA na habulin ng mga institusyong gumagawa ng anomalya at katiwalian. Regarding the proposed revision Presidential Decree number 442 or the Labor Code of the Philippines, siyempre po, buong suporta din po ako dito. It is both critical and timely to finally align antiquated provision which date back to 1974 with the current demands of Filipino workers, economic conditions, technological advancements, and existing international labor laws. Since its original enactment, binago na ng maraming batas ang labor code natin, lalo na sa aspeto ng labor migration. Lumawak at dumami ang ating mga OFWs, kung kaya't kinailangan natin ng Overseas Migrant Workers Act at DMW laws. These much-needed revisions and realignment will likewise enable our government agencies, especially the DOLE and the DMW, to adopt a harmonized and efficient implementation of our labor measures. Hindi rin malilito ang mga legal practitioners at lalo na ang ating mga manggagawa. Mr. Chair, I understand that the proposed revision will probably result in the production of 8 new books with 24 titles and 321 provisions. This might entail long and tedious process. As chairman of the Senate Committee on Labor, I hope that our initiatives in the Labor Committee will still run simultaneously with the steps to be undertaken by this committee. We have priority measures that also need in-depth and comprehensive discussions, such as the National Minimum Wage Law. This proposed bill is already under TWG. Other bills such as the Anti-Abuse of Pacquiaoan Workers Bill, Wage Step Bill, Magna Carta for BPO Workers, Construction Workers Protection Act, Anti-Endo Bill, and the Magna Carta for workers in the informal economy are also under consideration now by the Labor Committee. We intend to pass these legislative measures at the soonest possible time, and in the event na may maunang mapasa, we will propose that this committee may incorporate them accordingly in the revision by way of reference. Ganon din po sa Committee on Migrant Workers, we are now working on the passage of the Financial Literacy for OFWs and National Reintegration Bill. The passage of these measures will necessarily require further adjustments to the revised labor code. Finally, I would like to highlight the proposed abolition of the National Labor Relations Commission, or NLRC. This proposal will dramatically change the landscape of labor dispute resolution. In the past, madami akong complaints na mabagal daw po ang NLRC at totoo naman. Kayunpaman, napatunayan naman nila na in recent years na nag-improve at bumibilis na ang paglitis ng mga complaints sa kanilang tanggapan. Based on data submitted to us, mayroon silang high case disposal rate of 90 to 94% from 2020 to 2024. At sinasabi nila na ang nagiging cause of delay ay ang pag-akyat ng kaso sa Court of Appeals or sa Supreme Court. Dahil dito, mas mainam siguro na tanungin muna natin ang opinyon ng Supreme Court regarding this matter. Kailangang pag-aralan ng mabuti. If we abolish the NLRC, it will also mean creating new labor courts and expanding the judiciary. We must seriously assess both the pros and cons and what will ultimately serve the best interests of our Filipino workers. On that note, Mr. Chair, I reiterate my earnest support for this committee and the proposed measures in the agenda today. Wala po tayong ibang hangaring kundi mabigyan ng solusyon ang lahat ng problema ng ating mga magagawang Pilipino at mapaunlad ng tuluyan ang kanilang kabuhayan. Maraming salamat po, Mr. Chair. Magandang umaga po.
Thank you, Senator Raffy Tulfo. We assure the chairperson of the Committee on Labor that the measures that are pending before his committee that may have a bearing on this revision of the code will be taken into consideration, and that we are instructing our committee staff to ensure close coordination with the committee staff as well as Senate staff of Senator Raffy Tulfo in this regard.
Thank you, Mr. Chair.
And now we can proceed. We go back to the Department of Labor. Yusek Egargo, you have the floor for your presentation.
Thank you very much, Mr. Chair.
Senate Bill 1545. Go ahead.
Honorable Chairperson, honorable members of the Committee on Constitutional Amendments and Revision of Laws, distinguished guests, good morning. On behalf of the Department of Labor and Employment, we thank the Honorable Committee for inviting us to participate in today's deliberation on Senate Bill number 1545, authored by Honorable Senator Risa Hontiveros, which seeks to revise the Labor Code of the Philippines. We recognize the significance of this proposed measure. The Labor Code has long served as the foundation of labor policy and worker protection in our country. However, this evolving nature of the work, the emergence of new employment arrangements, and the need to harmonize with existing laws and international standards compel us to carefully examine the proposed revisions. Our initial review, we note that the bill is omnibus in scope, covering pre-employment, human resource development, conditions of employment, health and safety, labor relations, post-employment, and the gender equality provisions. While this is comprehensive, this approach raises important policy questions whether reforms should be pursued through piecemeal amendments or through a full-scale revision of this code. The department's comments will focus on key policy issues identified by our bureaus and the attached agencies, including but not limited to: 1. The regulations of online recruitment and the role of local employment services; harmonization of apprenticeship and training provisions with this TISDA and EBET laws; clarification of labor standards coverage; particularly for part-time work, NGOs, and evolving employer-employer relationship. Alignment of occupational safety and health provisions with our Republic Act 11058. Jurisdictional clarity among Bureau of Labor Relations, the NCNB, and the NLRC in labor dispute resolutions. Post-employment concerns, including grounds for termination and reasonable accommodation for workers with illnesses. And lastly, strengthening gender equality and inclusivity in the workplace. We emphasize that the DOLE's position will be guided by the principles of protecting workers, ensuring fitness and fairness in employment relations, and fostering industrial peace, while also considering the realities faced by employers and the demands of the dynamic labor market. Honorable Chairperson, we stand ready to work with the Honorable Committee of the Constitutional Amendments and Revision of Laws, with the Congress and our tripartite partners to refine this proposal. Our collective goal is to ensure that any revision of the labor code will be responsive, inclusive, and forward-looking, anchored on the constitutional mandate to afford full protection to labor, promote social justice, and advance the welfare of our people. Thank you very much, Mr. Chair, and honorable members of the committee, and we look forward to the fruitful discussion ahead.
Thank you very much, Yusek Gargo. Does the NLRC have a prepared position? You have the floor, sir. Go ahead. Commissioner.
Magandang umaga po, Mr. Chair, sa members ng committee at sa ating mga kasama rito ngayon. Ako po si Commissioner Hernan Nicdao ng NLRC.
Nicdao. Yes, go ahead.
Division po. Una po sa lahat, kami po ay nagpapasalamat in behalf of our chairperson, Grace Manikistan, sa imbitasyon ng committee ito. Napapanahon na rin po na talagang ma-review ang labor code. Ito po ay 51-year-old na po this year. So marami pong mga probisyon ng labor code ang talagang sinauna na at kailangan ng baguhin at ma-adapt sa mga makabagong panahon. Ang amin po lamang ay ang tungkol lamang sa abolisyon ng NLRC na napapaloob sa revised labor code na ating tinatalakay sa ngayon. As a brief background po, bago po nagkaroon po ng labor code, ang ating pong mga labor cases ay hinihear at dinidecide ng ating mga judges na under sa Court of Industrial Relations na nasa ilalim naman po ng ating judiciary. Bali po parang masasabi natin na trailblazer po ang NLRC because even 51 years ago, naisip na po nila na gawin pong magkaroon po ng conciliation, mediation, and arbitration processes na ngayon ay tinatawag na collectively na mga ADR or Alternative Dispute Resolutions ng ating Korte Suprema. At ang ating Korte Suprema po ngayon ay mas gusto na napupunta sa ganitong pamamaraan ng pagre-resolba ng mga kaso. So from the CIR po, napunta po sa NLRC ang mga labor cases, particularly po yung tinatawag na illegal dismissal and money claims cases. And sa loob naman po ng ilang taon, lalo na pong itong most recent years, mabilis po ang disposisyon ng kaso ng NLRC. Ang hinahandle po na kaso ng NLRC ay nag-average ng 30,000 per year. Napakarami po nito, subalit dahil po mabilis naman po at sa amin po kasi sa NLRC wala pong trial even po doon sa summary proceedings, hindi po siya summary proceedings na nagkakaroon pa ng presentation ng witnesses. Submission lamang po siya ng position papers. So, meron pong self-imposed na mga process cycle time ang National Labor Relations Commission. Sa labor arbiter levels po namin, ang aming process cycle time ay within 9 months kailangan pong ma-resolve ang cases. And sa loob naman po ng 5 taon, sa aming mga regional arbitration branches, nasa 91.46% naman po ang aming within the process cycle time na disposition. Ito pong nakaraang taon, itong 2025, nasa 97.85% po ang disposition within the 9-month period ng aming mga labor arbiters. Pag-akyat po sa komisyon, ang aming process cycle time ay 6 months. Ang aming pong process cycle time within the last 5 years ay nasa 97.09% at itong nakaraang taon, ito po ay nasa 97.22%. Overall po, ang disposition rate po namin ay nasa 99.87%. Ibig sabihin po, sa isang taon na pumapasok na almost 100% po, nauubos naman po namin ang aming kaso. Ang aming mga kaso. At ang affirmance rate po ng NLRC ay nasa 92.42% sa Court of Appeals at nasa 87.2% naman po sa Supreme Court. Patunay po ito na ang mga desisyon na nilalabas ng NLRC ay mga quality na mga desisyon dahil ito po ay ina-affirm ng ating Court of Appeals at ng ating Korte Suprema. While po kami ay subscribe po sa revision ng Labor Code, masasabi po namin na mayroon na pong institusyon, infrastruktura, personnel at expertise ang NLRC. Kung pong ito ay aalisin, masasayang naman po ang expertise na ito at maaari pa nga pong ito ay magresulta ng judicial congestion at yung tinatawag na encroachment ng rulemaking powers po ng ating Korte Suprema. Tungkol po rin sa nasabi ni kagalang-galang Senator Tulfo kanina na medyo meron pong konting kabagalan. Sa procedure po ito kasi, meron po yung St. Martin funeral case na na-enact na inilabas po ng Korte Suprema noong 1998. Prior po sa St. Martin funeral case, ang mga kaso po mula sa komisyon ng NLRC ay diretso pong umaakyat sa Court of Appeals. Pero po dahil po sa St. Martin funeral case, ang mga resolution or desisyon ng komisyon ng NLRC ay umaakyat muna sa Court of Appeals bago mapunta ng Supreme Court. Pero ito naman po ay hindi rin nating masasabing nakabagal ng disposisyon ng ating mga cases dahil po una po sa NLRC po sa labor arbitration, pag meron pong desisyon ang ating labor arbiter ng reinstatement, ito po ay immediately executory. So kahit na po sa ayaw at sa gusto ng respondent o ang employer o ang may-ari ng kumpanya, pag inutos po ng ating labor arbiter na merong finding ng illegal dismissal at kailangan ibalik ang empleyado sa trabaho niya, ibabalik po ang empleyado whether actual na reinstatement or payroll reinstatement. Pag naman po umakyat ang respondent, nag-apela papunta sa komisyon, hindi po mape-perfect ang appeal kung walang tinatawag na pag-post ng appeal bond na equivalent to the amount of the award. So ito po ay kumbaga nakakabawas ng mga apela dahil po kailangan magkaroon muna nga ng tinatawag na appeal bond. Pag po na-dispose naman ng komisyon ng NLRC ang kaso at nagkaroon na po ng finality pagkatapos ng motion for denial ng motion for reconsideration or resolution ng motion for reconsideration, magkakaroon na po ng tinatawag na issuance ng writ of execution. Ibig sabihin po, kahit po umakyat ang respondent, paakyat ng Court of Appeals, maaari na pong makuha ng empleyado na na-declare na illegally dismissed yung kanyang awards, yung kanyang monetary awards sa NLRC po. So, masasabi po natin na kahit na po na siya ay umakyat sa Court of Appeals, parang nagpa-final na rin po yung kanyang kaso. Okay? So hindi po natin masasabing ito ay nakakabagal pa rin dun sa kanyang kaso. Kung po halimbawang ma-reverse, number one po, mapipigilan lamang po ang execution nung pagbibigay ng monetary award sa empleyado kung mag-i-issue po ang Court of Appeals ng tinatawag na TRO or preliminary injunction, which in the past years po parang siguro mga 1 in 1,000 lang po kung mag-issue ang Court of Appeals ng TRO. So bihirang-bihira po sila mag-issue ng TRO tungkol doon. Kung halimbawa naman pong ma-reverse yung desisyon, yun pong reinstatement aspect at yung back wages, hindi na po yun, mahirap na po yun mabawi doon sa tao. So although meron pong yung tinatawag na restitution para naman po kung halimbawang talagang hindi just yung pagkakakuha ng award, maaari pong makuha ng employer yung undue na nakuhang award ng empleyado dahil na-reverse yung kaso niya naman pag-akyat ng Court of Appeals at ng Supreme Court. Overall po, instead po ng abolition, what we seek from this honorable committee is to further strengthen po yung NLRC. Sa ngayon po, Ang NLRC po, halimbawa po sa aming mga labor arbiters, kumpara po sa isang regular court, ang aming pong staff per labor arbiter is dadalawa lamang. Isa pong labor arbitration associate at isang researcher. So ang mga regular courts po ay mayroong mga 10 hanggang 15 na staff. So doon po kami nahihirapan. So kulang rin po ang aming mga arbitration branches. Sa palagay po namin, repressed pa po yung ating mga cases, especially sa mga probinsya. Kasi po ang aming, unlike po ng courts, ang presence lamang po namin is per region. Although ngayon po, nagtratry po kami mag-expand. Halimbawa po, nagtayo po kami ng aming sub-arbitration branch sa Taytay para to cater po. Kasi halimbawa po, no, ang arbitration branch po namin sa Region 4A ay nasa Calamba. So malayo po yung Calamba sa mga taga Rizal, taga Cavite. So kami po ay nakikipag-partner sa mga LGUs. Baka pwede kaming bigyan ng libreng opisina para po kami ay makapagtayo ng sub-arbitration branches po sa mga lugar na malayo po dun sa regional offices po namin. Ganun rin po ang ginagawa namin even po rito sa Metro Manila. Mahirap lamang po dahil mahirap pong humingi ng budget sa DBM. So kailangan pong kami ay manghiram ng opisina or pahiramin ng opisina ng mga LGUs para po kami ay makapagtayo ng arbitration branches sa mga malalayong lugar na ito sa aming mga main arbitration branches. Isa pa po, no, samantalain ko na rin po, yung aming pong building, finally po, after 50 years, meron na pong tinatayong NLRC building. Ito po ay narito po rin sa OSH compound dito sa may Agham Road po sa Quezon City. Pero this year po, it's supposed to be a 3.4 billion na 17-story building na tinatayo. Pero unfortunately po, for the last 5 years, wala pa po yatang 1 billion yung nare-release na pondo ron sa building. This year po, zero po yung budget na ilagay po sa kanya. So again, hindi lamang po sa budget, sana po sa revision po ng labor code, mas maaari pa pong mapabilis yung mga proseso namin sa NLRC, magkaroon pa ng mga dagdag na transparency measures. So again, instead of abolition, what we're seeking is further strengthening of our institution. Magandang umaga po, Mr. Chair.
Yes, Commissioner, can you submit to this committee your position paper?
Yes po.
As to the alternative to abolition?
Yes po.
So that we can incorporate it during the discussions.
Yes po.
Okay, thank you. We can now proceed with the GCG. The chairperson, Corpus, you have the floor, sir.
Good morning, Mr. Chair, Your Honors, Senator Pangilinan and Senator Hontiveros. The GCG is the Central Oversight and Monitoring Body for government-owned or controlled corporations. We have already submitted our written comments and position paper on the proposed bill, Senate Bill 1545. But we can read into the records of this particular hearing the highlights of our comments should the...
Yes, please, go ahead.
Thank
Go
you,
ahead,
thank you, Your Honor.
Sir.
Article 17 of Senate Bill 1545 prohibits government officials, employees of various state agencies, and personnel of GOCCs with original charters, as well as their relatives within the fourth civil degree of consanguinity or affinity, from engaging in the recruitment and placement of workers for overseas employment, whether for profit or not. Now, the proposed article limits it to GOCCs with original charters. We submit that this provision is on accountability and ethical standards, so that we propose that even officers and employees of non-chartered GOCCs should be included in the prohibition, Your Honors. On Article...
Could you give us an example of a non-chartered GOCC?
Clark Development Corporation, Your Honor. It's a subsidiary of the BCDA. Yes, Your Honor.
Okay, thank you, thank you.
Yes,
Please
sir.
proceed.
Yes, thank you, Your Honor. Article 79 on the definition of GOCC, or defines, gives a revised definition of an employer and provides that the employer includes any person acting directly or indirectly in the interest of an employer in relation to an employee, and shall include all government-owned or controlled corporations and institutions without original charter, as well as non-profit private institutions or organizations. We note, Your Honors, that this revised definition aligns with settled jurisprudence, which provides that GOCCs with original charters are governed by the Civil Service Law, while non-chartered GOCCs are governed by the Labor Code. Now, the Commission has no objection to this redefined, this new definition of employer, Your Honor, but perhaps we might humbly submit, Your Honors, that maybe we can revisit the distinction between officers and employees of chartered GOCCs and non-chartered GOCCs, because non-chartered GOCCs usually promote or carry on the mandate of their parent GOCC, the public policy mandate or the public welfare mandate of the parent GOCC, as well as the supervising agency, Your Honor. So maybe it may be time to revisit the distinction between chartered GOCCs and non-chartered GOCCs. Like in the example of the Clark Development Corporation, they carry on the mandate of the BCDA as well as the Department of Transportation, Your Honor. On Article 171, Your Honor, the appointed members of the Employees Compensation Commission, it reaffirms the nature of the Employees Compensation Commission as a GOCC under the coverage of Article the Republic Act number 10149 or the GOCC charter, the GCG charter, Your Honor. So as a consequence, the appointed members of the Employees Compensation Commission, as well as the Executive Director, must undergo the selection and nomination process of the GCG in accordance with Section 15 of RA 10149. The one-year term for the appointed directors is also consistent with Section 17 of RA 10149, which provides for a one-year term of the for the appointed members of governing boards of GOCCs. Now, on Article 171B, on the per diems of the ECC board, the GCG respectfully proposes that the per diems of the appointed members of the Employees Compensation Commission should be the same as the members of the governing boards of GOCCs similarly situated. And we humbly proposed this particular wording of this Article 171B, Your Honor. And I quote, "The appointed members shall receive such compensation, per diems, allowances, and incentives as may be authorized and determined by the Governance Commission for GOCCs, pursuant to the provisions of Republic Act number 10149, Executive Order number 24, series of 2011, and any subsequent issuances thereof," close quote. For the record, Your Honor, the Governance Commission has already submitted a recommendation to the President to increase the per diems of the members of the governing boards of GOCCs, because the basis, the implementing Executive Order number 24 was in 2011, and considering the inflation, Your Honor, we have proposed to the President to increase the per diems of the members of the governing boards of GOCCs. Now, as to Article 249 of the Senate bill, we propose that this be harmonized with Section 9 of Republic Act 10149, which provides, and I quote, "Any law to the contrary notwithstanding, no GOCC shall be exempt from the coverage of the compensation and position classification system developed by the GCG under this Act." End of quote. So, Your Honor, this effectively excludes economic provisions in the bargaining with the governing board or the ombudsman of the concerned GOCCs between the GOCC and its employees. And this also is in accordance with the Supreme Court decision in GSIS Family Bank Employees Union and Villanueva versus Villanueva, which states that the GOCC governing boards, chartered or non-chartered, may not negotiate with their officers and employees on the economic terms of their respective collective bargaining agreements. So we propose that this be explicitly stated in the proposed Article 1249, Your Honor. And as a consequence, Your Honor, since the coverage of the CPCS, or the Compensation and Position Classification System, applies to both chartered and non-chartered GOCCs, the right, although we would respect the right to self-organization, but the right to strike of officials and of employees of both chartered and non-chartered GOCCs be subject to the Civil Service Law and also Executive Order Number 180 of Series of 1987, which expressly prohibits strikes and work stoppages that disrupt public service. As we earlier said, Your Honor, even non-chartered GOCCs carry on the mandate, the public policy mandate or the public welfare mandate of their parent GOCCs. So we submit that there should be no distinction between chartered and non-chartered GOCCs as far as the right to strike is concerned. Although we must emphasize that we do recognize the right to self-organization of this employees association. In fact, Your Honor, the GCG also meets with the employees associations of GOCCs to discuss their concerns about their welfare compensation, Your Honor. And just for the record, one of the issues that was raised by these employees associations was the lack of HMO coverage in the under Executive Order Number 150 Series of 2021. And when we met with this the employees associations, we were able to endorse to the President for approval the provision for medical allowance for GOCC employees, which will take care of their HMO requirements, Your Honor. So even if there is no right to bargain on economic conditions for GOCCs, the Governance Commission still considers the position of the employees, Your Honor. That is about the highlights, Your Honor, of our comments. There are other non-substantial comments, but that would be the substance of our comments on the proposed legislation, Your Honor.
Thank you, Chairperson Corpus. We go back to, the attached agencies. May position paper ba ang Bureau of Working Conditions? Bureau of Labor Relations, or do we take it that your position is the same as the Department of Labor?
I will just submit our position paper as a whole,
Okay.
Mr. Chair.
Okay, thank you. What about the NCMB, the National Conciliation and Mediation Board? Same? You will just submit?
The same, Your Honor.
And we've heard from the NLRC. Okay, so we can now proceed with, I understand, the UP. No, wait. Ulit. The ICT. Oh, yes. DICT, would you like to manifest? Go ahead, please.
Yes, Mr. Chair, thank you for allowing DICT to be part of this committee. Although the DICT is not actually expressly included in this enhancement or of the law, but the DICT, we have several recommendations, Mr. Chair.
Yes, you're actually a resource person for the audit code, but please feel free to have your position on the matter of the labor code revisions. Go ahead.
Yes, Mr. Chair. So since the DICT's mandate is more on the interoperability and process simplification, and I think piles of paper, manual entries, and that actually hurdles a lot of things and elongate a lot of processes. But in the new world, if we're going to simplify this and making things more simpler by automating things, I think we're able to put solution to a lot of delayed activities, especially in the manual monitoring, documentation, and the like. So the DICT is also involved, Mr. Chair, on the First-Time Job Seekers Act. And we are also involved in implementing the Ease of Doing Business Act as well. And under the anti-red tape law, or the RA 11032, it says there that there are a specific period of time that the agency should respond according to the uh, uh, example. For the simpler transactions, the agency should respond in 3 days. For a minimal response in 7 days, but in a more complicated and technical issues like the labor, like the one that explaining a while ago in the NDLRC, I think under the law it should be 20 days. At least the agency should respond, not 6 months in 20. But since this is a filing of cases, I understand that there are complexities in terms of that process. But just to manifest, Mr. Chair, that the DICT is ready to, and we are really in support of this initiative. And it's about time to embed technological advancement, not only to simplify things, but also to make sure that we can automate some of the processes and come up with the real-time monitoring. In fact, Mr. Chair, we're working together with COA on the transparency system, where every data that should be entered in a certain agency, there should be a multi-layer of transparency, meaning if the agency will enter data, COA also should see it. And also the agency also should see it, so that there will be no alteration and there will be more responsive way of doing things. Kasi kapag wala kasi nagbabantay, Mr. Chair, at isa lang ang nakakakita sa isang data, hindi minsan gumagalaw. Pero pag marami ang nakakakita ng documents at yung mga proseso, mas gumagalaw po siya. So Mr. Chair, we are really excited and in support of this revision of the law. Mr. Chair, thank you.
Maraming salamat. We now go to the UP Law Center. I understand you also have a presentation. Go ahead, sir. Attorney De Vera.
Thank you, Mr. Chair. Mr. Chair, with all due respect, I noticed that the National Wages and Productivity Commission Executive Director is here. I'm not so sure if they will also be adopting the DOL, but usually in these discussions, NWPC presents separately. If the chair would like to just ask them. Thank you.
Do you have a presentation? Executive Director Christina
C.
Griselda.
Yes.
C. Go ahead, ma'am.
Mr. Chair, we will also consolidate with the position our technical inputs.
Thank you. Thank you, ma'am. Go ahead, Attorney De Vera.
Thank you very much, Mr. Chair. To the chairperson and to the members of the Senate Committee on Constitutional Amendments and Revision of Codes, thank you very much for your invitation. And thank you very much for this initiative on looking at our 52-year-old labor code. I am here. I am Arnie De Vera. I am now the current director of the Workers and Employees Program. I am joined by the founding director of the Workers and Employees Program, Professor Dawai, who's seated at the side. I take my inspiration from her, Mr. Chair, and dear senators, because I would have to tell you about the enormity of the task that we present before you. And this project, which started in 2011, thank you for the presentation, from 2011, stems from certain visions. And one vision is to realize the constitutional recognition of labor as the primary social economic force. And secondly, of the vision of the Constitution to realize certain rights under Article 13, Section 3 of the Constitution itself. That's the third slide already, please. Thank you. And please note that, as has already been described, our current version of the Labor Code stems from Presidential Decree 442, 1974, took effect on November 1, 1974. And from that time, has been amended piecemeal from time to time. All these facts may become relevant as we go through the salient points. Another portion, and if you will notice, ladies and gentlemen, I am also trying to fit my whole presentation within the 5-minute limit. If in the next slide, I will present to you the experts who joined one another in order to come up with the present proposal. From 2011 and formalized in 2016, the project culminated in the present form of the proposals in 2022. The timeline is relevant because I would have to flag this early that some of the proposals have already been overtaken by better measures, which have come in between 2022 and the present time. The Workers and Employees Program of the University of the Philippines did not think it prudent to change anything that was proposed in 2022 because we could not carry the same imprimatur or approval of the same experts, which included, for example, as I mentioned, Professor Dawai, who's here. It also included Dean Bartolome Carale, who was an NLRC chair himself, Dean Antonio Abad.
He was my dean.
Yes, sir. Thank you. Professor Leo Batad, Attorney Ismael Khan, all experts in labor law, Professor Francis Sobreviñas, Justice Vicente Veloso, also a NLRC commissioner beforehand, and myself included. There are other names, but I guess I just wanted to put the point across that when the discussions were being done for this revision of the labor code, certain interests were represented both from management, from government, as well as from workers. It was very difficult coming up with a consensus, but the resulting proposal before you is a result of consensus among colleagues as well as experts. So allow me please to also say in the next slide that certain agencies were called from time to time to give their views on the proposals. So what did they now try to do? In the next slide, the purpose of the proposed labor code can be summarized as follows. First is to incorporate existing laws, those that came to effect at least by 2022. I would have to flag this early that, for example, certain laws like the expanded maternity law has not been incorporated here because by the time that book was finished by the experts in 2019 had not come about just yet. Also, the Department of Migrant Workers Act was only incorporated at the last minute because it was passed 2021 just before the panel of experts were concluding their work. The second purpose is to ensure that interests of laborers and employers are equally protected. Third is to ensure that gender fair and non-discriminatory language as well as concepts are integrated into our labor code. And last, to provide a comprehensive and easily accessible labor regulation in order for experts, users, as well as stakeholders to have only one document before them in order to refer to labor laws. Presently, we can refer to PD 442 as the main law, but we will have to go through different Republic Acts in order to go through piecemeal legislation that have come since 1974. It is correct in the next slide that the resulting proposal contains now 8 books compared to the current 7 books of the Labor Code. This hews very closely still to our present Labor Code, keeping the logic from pre-employment up to post-employment. However, newer provisions need to have a certain focus. For example, Book 7 is now proposed for gender equality provisions, just to update our labor code provisions, which had been passed within the context where these sensitivities were not yet occurring. In the next slide, allow me please now to go to the salient points of each proposal. In the preliminary title, there is immediate emphasis placed on non-discrimination as a concept as well as a vision of the new law. On account of race, color, sex, gender, sexual orientation, gender identity and expression, marital status, age, disability, language, religion, political opinion, national extraction, or social origin, these are explicitly enumerated as basis for discrimination which should be prohibited and avoided. I will have to also flag that stipulation against marriage discrimination, for example, will now apply not just to women as it is now, but also to men. Classification of certain workers, which is an existing article in the labor code, which currently only applies to females or women, should be also applied to without discrimination. In the next slide, on pre-employment, the major revisions and proposals involve the capital needed because it has not been updated since the recent amendments to RA 8042. There is a bond requirement which have also been updated in terms of amounts. And the next slide, still on pre-employment. Please note that the newer amendments involving the Public Employment Service Office, or PESO, have been already integrated. Right now, they are not an integral part of the labor code. Portions of the RA 8042 and its amendments after that have been integrated into the labor code. Right now, there is, again, main body of PD 442, and then several RAs, Republic Acts, parallel to it, which regulate migrant workers, 8042 being the main one. There is also a need to update the title on employment of foreign nationals. As of now, the current proposal is based on what was then the Dole Department Order 186-17, but it can easily incorporate the newer amendments under DO 248-A, which was just recently issued in 2025. I will have to flag po na with the recent issues also on foreign nationals seeking employment here, whether legally or illegally, this provision of the labor code needs urgent examination as well as updating. The next po on book 2, there. There is a proposal to remove the concept of learners because as the experts deliberated and discussed, they discovered that the concept of learners is not being used anymore. Despite the fact that this is still being learned by rote by students and even asked in the bar, there is very little application in real life. Apprenticeship is retained but updated also with regard the minimum age as well as with the procedure by which apprenticeship can be applied for.
Attorney De Vera,
Yes, pa.
you have a lot of pages to go, huh? So
Yes, sir.
maybe you should sort of focus
Yes.
on highlights. Go ahead.
I can focus on the salient points,
Yes, please.
Mr. Chair.
Thank you.
Thank you.
Proceed.
With regard to conditions of employment, what has received a lot of attention, and this is on, I think, the next slide on book 3, is the proposal to change our regional wage fixing mechanism to one which is national. I will now go to book 5 just to expedite discussion.
Just on that matter,
Yes.
why do you deem it necessary to renationalize the regional wage boards?
There are many reasons, Mr. Chair, chief of which is the perceived inequity right now, presently, between the regional wage levels among regions. where for example, NCR has a 695 wage level, and we have regions, for example, which still has about 413 or 430. While there are formal reasons for it, the experts believe that this is now unjustifiable, especially with regard the gap in between, and that there is a better way of setting it, which is by industry rather than by region.
Please proceed. Thank you.
Thank you, Mr. Chair. Allow me to go to Book 5. And again, I turn to this one, and there's a slide just on Book 5, because there has been preparatory discussions already on what has been described as the abolition of the NLRC. And I would just like to describe the process by which this was done. And it starts from a description of the current situation. Can you switch to the next slide, please? Where the current situation, we see ourselves faced with most labor disputes facing at least 4 or 5 levels of dispute resolution. And even if, for example, and this one, Mr. Chair, I hope I can engage the discussion earlier already began. While we appreciate the count of the NLRC with regard to dispositions, it would really depend on how the periods are counted. The 91% and the 97% are very much appreciated. However, from the experts' point of view, we looked at the current labor code, which actually gave out certain periods in order for the disposition of cases. And for example, in the labor arbiter level, the labor arbiters are supposed to sorry. The labor arbiters are supposed to dispose of them within 30 calendar days after the case is submitted for decision, not 9 months. NLRC are supposed to dispose of them within 20 calendar days from receipt of the answer of the appellee. These are existing legal provisions. And I guess we're at that point where we have to say, are we going to extend these deadlines, or are we just going to change the whole process itself? The proposal actually is just mainly boils down to 2. One, have all the labor disputes faced with a professional, trained mediation body, all still under the same body. If the dispute remains unresolved, then the dispute can now go to compulsory arbitration, which is the current procedure now. After that, I have to confess, Mr. Chair, there was no consensus among the experts. It is correct what has been said earlier, that some experts still wanted to respect the Court of Appeals process up to the Supreme Court, but there was still an insistence that maybe, even with Supreme Court advice, that the appeal could be shortened from the NLRC or from whatever body it will be created directly to the Supreme Court. Again, shortening the process. There is just a last point on this, Mr. Chair. One of the latest decisions rendered by the Supreme Court that has garnered news attention is the one on the talents in the GMA 7. And that case, according to reports, lasted about 11 years in litigation. That is the process that we're trying to avoid. Even, for example, even if it is the opinion of others that that is an exception more than the rule, we have to avoid that exception as well. That's on the Book 5, Mr. Chair. On Book 6, on post-employment, there's just an update on the causes for termination. There is a specific identification of sexual violence and other sexually related offenses as a just cause for termination as an additional ground. There is a recognition to insert the requirement for a public health authority certification for the ground of disease to become a legal cause for termination as well. Then I'm already wrapping up, Mr. Chair. On gender equality provisions, there is a slide just summarizing the requirements in order not just to provide for provisions on gender equality in the new labor code or the revised labor code, but also a process in order to ensure that this is done in actual practice. And then, of course, with all the changes, the experts also tried to put in transitory provisions, which is put under Book 8, Mr. Chair. And thank you very much for your patience, Mr. Chair. That is where I end my formal presentation. Thank you very much.
So, Attorney De Vera, what class were you? I assume you graduated in UP, is that right?
Yes, Mr. Chair. We were actually classmates in at least 2 classes, Mr. Chair. I graduated in 95, Mr. Chair.
Okay, because I was classmates to many batches. I took 2 years leave of absence because of elections, and it was an evening class. So that's 5 + 2, 7 years. So yeah, nag-abot tayo. Maybe you were a sophomore when I was your classmate. Okay, thank you. But like me, medyo pumuti na buhok mo. Oo. Thank you for your presentation, Attorney De Vera. Partido ng Manggagawa, Mr. Renato Magtubo.
Thank you, Mr. Chair.
Former member of the House.
Salamat po at magandang umaga po sa ating lahat, Senator Risa. Wini-welcome po namin.
Currently konsehal sa Marikina.
Yes po. Konsel po ngayon. Salamat po sa imbitasyon at kami po sa Partido Manggagawa at kasama na yung mga alyansa ng Kaisa Labor Coalition ay wini-welcome po ito at sinusuportahan ang panukalang pagbabago sa Labor Code. Ngunit meron kaming mga issues and concerns na sana ay pag-usapan sa gitna ng mga panukala para sa pagbabago. Halimbawa po nito ay, yung pagbabago ba sa Labor Code ay i-address niya ang perennial problem of unionization at coverage ng collective bargaining agreements. Kasi yan ang problema sa ngayon. Matagal ng panahon. Dumadaos-dos ang bilang ng magagawang nag-union at covered ng collective bargaining agreements. Alam naman natin sa pag-uunyo at collective bargaining agreements, maraming nare-resolve dyan. Na-resolve yung usapin ng sweldo, na-resolve ang usapin ng grievances, at nare-resolve at nakakatulong siya sa maintenance of sound labor relations. Pero problema yan. Ang sabi nga namin, sa pagbago sana ay gayahin natin yung logic ng business. Kung merong ease of doing business, dapat meron ding ease of organizing unions and the right to collectively bargain. Yun pong isa. Pangalawa, amin namang inaamin na may pagbabago ng sitwasyon at employment relationships. Bunga ng mga pagbabago din sa disenyo ng business. Pero pagbabago ba sa panukala ng labor code ay may address ang sinasabi ng Constitution right to security of tenure at yung proliferation of contractual employment. Kasi problema yan. Sa ngayon, noon hanggang ngayon, na kapag ikaw ay nakakontrata lang sa iyong trabaho at nangangamba na pagdating ng kontrata ba wala ka ng trabaho, yung karapatan mo na mag-exercise ng to organize, collectively bargain, ay nawawala din. Sapagkat ang kasikasuhin mo ay pagkapagtrabaho at natatakot kang yan ay magagamit sa iyo laban ng mga employers. So yun, ma-address ba yan? Yung proliferation of contractual employment at yung security of tenure ng mga manggagawa regardless of employment relations dahil sa pagbabago. Diba? Pangatlo, yung dispute settlements natin. No? Kasi habang humahaba yan, maraming stages, talo manggagawa dyan. Kasi wala siyang resources eh. Hirap na nga kumuha ng abogado, diba? Hahaba pa yung yung stages ng pag-resolve ng kaso, mauwi na lang yung mga manggagawa, magbabayad na lang sa halip na ilaban yung kaso niya. So ba-address ba yan ng pagbabago sa labor code? At panghuli, siyempre, yung mandato ng konstitusyon ng living wage. Ito bang pagbabago sa labor code ay patpunta doon sa ating inaasam aspirations na magkaroon ng just and living wage sa mga manggagawa? Yun po ang inaasahan namin. Kami po ay bukas sa mga panukala at diskusyon sa mga stakeholders para maabot yung concerns na yan. Alam nyo, nung nasa Congress ako, nag-file din ako ng omnibus amendments sa Labor Code noong 13th Congress. Pero hindi siya umusad. So ito na siguro pagkakataon, pangalawang pagkakataon para sa akin na isalang natin ang omnibus amendments na yan to address yung nasasabi ko ng perennial problems ng mga manggagawa. At syempre, ma-incorporate na rin ang marami pa mga pagbabago sa Labor Code para sa proteksyon ng ating mga manggagawa. At nasisiyahan kami ng proposal na ngayon, i-discuss natin from the UP law ay nakaangkla doon sa konstitusyon natin. Sa Section 3, Article 13 of the Constitution, na malinaw na may sinasabi na maraming karapatan na dapat 1987 pa nakalagay sa Constitution pero hindi pa nakukuha ng mga manggagawa. So kami sa Partido Manggagawa at ibang mga alyansa ng manggagawa ay bukas at makipagtalastasan at makipagpalitan ng panukala na sa ganon maabot natin ang inaasam na pagbabago sa konstitusyon bilang proteksyon sa manggagawa at sa employer din sa isang banda at sa pag-unlad ng ating ekonomiya. Magandang umaga po sa ating lahat.
Salamat po, Rene. Chair Rene. Isa-second guess ko yung planong sequence ng resource persons ni Chair who will be right back. At i-recognize ko naman yung Secretary General ng Philippine Metal Workers Alliance, Reyra Singh. You have the floor.
Magandang umaga po sa Madam Chair, Senator Risa. Yung posisyon po ng Philippine Metal Workers Alliance, ito po yung federasyon ng mga union sa automotive saka sa metal. At mostly nasa Southern Tagalog kami saka sa Region 3. Partly din dahil naging sinusuportahan namin yung panukala din ng UP Law Center dahil nakabahagi ho kami doon sa WEP program ng UP Law Center. Pero yung isang matingkad na kung nga namin na nabanggit ni kasamang Rene ay yung issue ng freedom of association. Kasi for instance, under sa Labor Code, bawal ho ang interference ng management sa mga CE proceedings. Actually, bystander lang po sila. Pero sa katotohanan, pagdating ng eleksyon ng union, ay talaga nakikialam yung management. So under the law, ang kailangan lang para mapatunayan na guilty ang employer ay substantial evidence. May isa kaming case which was last year, nagsusuot ng pin na no union sa loob ng kumpanya, yung mga empleyado. Nagpamisa yung management na nakapin at t-shirt ng no union yung mga empleyado na sinusuportahan ng management. Pero despite yung mga ganito, ang sinasabi ng DOLE, dapat daw may nag-execute ng affidavit. Pero alam naman namin sa totoong buhay, pag isang empleyado ng kumpanya ay nag-execute ng affidavit laban doon sa employer, siguradong yon ay bilang na ang araw niya sa kumpanya at gagawan ng paraan na matanggal. So ngayon, nakapending po ngayon yung aming kaso na yan sa Court of Appeals. Despite yung mga pictures at manifestation na inilatag namin sa during the CE proceedings. Pangalawa ho ay yung pandem. We have some cases na nanalo ka na nga na SEBA na certified na sole and exclusive bargaining agent, pero ang gagawin ng management magfa-file ng kung ano-ano at sasabihin na hindi pa kami haharap sa collective bargaining negotiations. And we have several cases in that regard. Yung iba ay ngayon 7 taon na, wala pa rin CBA despite the fact na nanalo sila sa certification election. So yun yung isang gusto sana namin na mapabilis yung lahat nanto. At kung if ever, ma-penalize din yung mga employers. Hindi ko sinasabing lahat ng employers ay ganon, pero yung mga one of a kind na hindi sumusunod sa ating labor code ay sana mapabilis din na maparusahan. Pangatlo ay yung sa may panukala kami through the NAPSI Formal Labor and Workers Sectoral Council na kahit mismo yung certification election ballot ay palitan at tanggalin na yung no union na choice. Kasi kung for example, nag-file ka ng petition for certification election, yung union na lang yun. Either gusto ko bang maging member ng union na to or hindi. Kasi marami kaming cases na pag may mga choices, dahil sa galit sa no union, pati yung no union iniikesan. So yung mismong balota, of course, kung na yun, null and void na yun. So yun po yung kwan. Bagamat officially po ay paabot na sa Bureau of Labor Relations yung panukalan na to na galing sa formal labor ng NAPSI. Pang-apat ay yun nga sinabi kanina ni Attorney Arnie, yung sobrang kwan. May prescriptive period para after submission pero hindi nasusunod. At hindi na yan alam naman whether employer yan or mga sa labor, alam nila na laging lagpas yung kwan. I would understand siguro dahil sa sobrang dami ng workload din ng mga labor arbiters at mga commissioner. Pero yun nga, habang patagal ng patagal, hindi lalong nawawalan ng pag-asa yung mga nagfa-file ng mga union members namin. At kadalasan, tatanggapin na lang yung kwan. So generally po, we will support yung panukala ng UP Law Center in terms of changes doon sa ating labor code. I think panahon na dapat yung mga provisions na naipasa noong panahon ng diktadurya ay dapat mapalitan na rin para sa changing times natin sa ngayon. Marami pong salamat, Mr. Chair.
Maraming salamat sa Metal Workers, Metal Alliance, Philippine Metal Alliance. Yung NAPSI, Mr. Lacerna, may position paper kayo?
Your kind indulgence, Mr. Chair.
Go ahead, please.
Yes,
we have 5 minutes. Go ahead.
We are part of the consultations done by the UP Law Center, as Attorney Rivera said, and my colleague from Philippine Metal Workers Alliance. We've been part of the consultation, and we provided some our inputs. However, magbibigay po kami ng position paper to incorporate those developments, mga bagong issuances, recent Supreme Court rulings, at yung mga aming mga recommendations, especially doon sa freedom of association. So, Mr. Chair, we will submit our position paper by the next meeting.
Okay.
Or before the next meeting.
Yes.
Thank you.
Maraming salamat, Mr. Lacerna. Yung sa TESDA, would you have a official position paper or you will submit? Okay. And yung occupational safety and health, you will submit your position? Okay, good. So, ma'am, we're done with the, unless, hindi, ang OSG ba? Yes, auditing code, tama. Go ahead, ma'am. You have the floor.
Salamat, Mr. Chair. Siguro tatlong pangkalahatang paksalang ang gusto kong tanungin. So, una po, tungkol dun sa shift sa judiciary. So the creation of the Court of Labor Relations would shift dispute resolution from the executive branch o yung NLRC DOLE to the judiciary, particularly the Supreme Court. So address yung follow-up question ko dito sa mga advocates nitong shift. So siguro si Attorney Arnie De Vera muna. naniniwala ba ang mga advocates na yung shift na ito kasabay nung rule na ang mga proceedings ay mananatiling summary at saka non-litigious ay sa aktual magre-resulta sa mas patas, less politicized, at saka mas mabilis na outcomes para sa mga manggagawa?
Madam Chair, yes po. Mabilis pong sagot po doon ay yes. Makikita po siguro na mas mapapanatili po siguro yung tingin at yuko doon sa mga deadline na nilalagay ng mga alituntunin kung mayroon talaga pong tumitingin at sinasabing masyado nang matagal yung pagre-resolve nyo ng kaso.
Kung ganon, Attorney Arnie, anong tingin nyo dun sa pananaw ng NLRC o panukala, no, na at alternatibo na sa halip na i-abolish yung NLRC at ilipat sa judiciary itong dispute resolution, ay sa halip ay palakasin na lamang ang NLRC sa mga usapin ng staff, mga branches, budget at saka building nila?
Maraming salamat po sa tanong na yon, Senator. Banggitin ko lang po na kahit po siguro baka bago itong panukalang to sa pandinig ng marami, tama po yung sinasabi ni kasamang Rene kanina na medyo 2012 pa o 2011 may mga ganito na pong panukala, no? Kaya ako naman po nagsimula doon kasi alalahanin ko po nung kami nag-aaral pala po ng batas, 15 pa lang po ang commissioners ng NLRC. When there was a proposal or a set of proposals to also change the labor dispute mechanism, the other counterpart was to strengthen, those were the words used, and to add more commissioners. That became law in 2006 through RA 9347. From 15, naging 23 po yung commissioners. No? And there's a more recent law in 2016 which also strengthened the NLRC. So medyo ilang beses na po natin pinalakas ang NLRC. Ang tanong lang po ay, when will we reach that point where we can admit that the system has reached its limits and maybe it's time also for an overhaul of the system itself? Wala naman pong problema. Like for example, if in the interim, kasi alam naman po natin mahaba yung usapin natin dito, if in the interim NLRC needs all the strengthening that it needs, wala pong problema. But if in the horizon, ay pwede talagang palitan yung buong labor dispute settlement mechanism, mas maganda siguro pong dulo yun. Kundi, siguro project natin another 10 years from now, baka magdadagdag na naman po tayo ng tao doon sa NLRC dahil kukulangin na naman po. It's exactly the same po na discussion during that time na kulang yung tao kaya po mabagal during that time. I also joined the discussions during that time. But now, we hear exactly the same limitations, which could really be true. But that is not the fault of any one person. It may just be the fault of the system itself, which needs to be changed.
So, salamat. Ibig sabihin, meron kayong institutional memory, hindi lang sa NLRC as a structure, institution, pero yung naging kasaysayan din ng pagpapalakas at pagpapareforma nito. So, mula 15 commissioners, naging 23 na. So, actually napalakas by about 60% from its original number. So, I hear you loud and clear na baka hindi yung bilang ang problema o limitasyon, baka yung sistema mismo. Sabi nyo nga, it may have reached its limits. At the same time, narinig ko yung sinabi nyo, baka may interim na may strengthening. So, siguro, Mr. Chair, we can explore pati sa technical working group, if may transition period ba ito, magiging in phases ba ito, a few phases, yung shift na ito sa judiciary, kung yun po ang mapagkasunduan ng komite. So salamat, Attorney Arnie. Yung susunod na tanong ko po ay dun sa paksang industry-specific wages. So the bill proposes shifting from regional minimum wage fixing to national industry-specific minimum wages by establishing industry tripartite wages and productivity boards. Actually, Mr. Chair, isa sa pinaka-provocative na mga panukalang narinig ko in the past years from the labor movement. So kung isama po ito dito sa Senate version, gusto kong tanungin sa DOLE, paano po pinaplano ng DOLE na i-manage yung administrative transition sa industry-specific wage fixing at paano naman sisiguruhin ng department na yung mga pangangailangan ng mga manggagawa sa iba't ibang rehiyon ay matutugunan pa rin. If the good USEC Egargo would like to answer.
Your Honor, may I request Executive Director C to respond.
Thank you, Mr. Chair. So, Executive Director C po.
Thank you, Madam Chair. And with the permission of USEC Egargo, if we're going to shift from regional to industry level, it's going to be an administrative challenge, Madam Chair, because right now, for example, if we will use the existing PSIC, there are 21 major sectors. And then if you're going to move to the second digit, there's going to be 88 additional sectors. And if you go into the third level, nasa 235 po yun. So I do not exactly know how the UP would want it done, but it's going to be really an administrative challenge for us because, for example, in the manufacturing industry, in the industry sector, you have manufacturing industry, and in the manufacturing industry, there are a lot of sub-industries like food industry, etc. So sa tingin po namin...
Just on that point, food industry, ano pa ang saklaw ng manufacturing?
We have po food, beverage, tobacco products, textile, wearing apparel, wood products.
All under manufacturing?
Yes po, electronic, machinery, motor vehicle, furniture. So, ang nai-imagine po namin na magiging difficulty po dito is similar to the experience of the Regional 4A or Calabar Zone na yun hong inaatake ngayon about the provincial rates. Na in fact, ito pong provincial rates nito ay halos wala na po ito ngayon sapagkat dun sa bagong wage order po ng 4A ay tatlong areas na lang po yung categories nila. So you have the cities and first class municipalities, second and third class, and fourth and third class, fourth and fifth to sixth class municipality. So nabawasan na po yung wage rate sa Region 4A from a high of 40 rates in 2010, ngayon po ay nasa 3 rates na lang po. So, yun po yung nakikita namin. Kaya ang sa tingin po namin, it is important to keep, as it is right now, the minimum wage as complex as necessary to take into account the varying socioeconomic circumstances in the regions, but as simple as possible, taking into consideration the country's institutional capacity, the quality of statistics that is available, because if you're going into very detailed industry specific, magsasuffer ho yung quality of statistics and indicators that we will use, because right now ang official statistics po ng PSA karamihan ay nasa third digit lang po. And then the more important consideration naman on the part of the Department of Labor and Employment is the enforcement capacity. In terms of labor administration, tulad po ng nabanggit ko kanina, nagkaroon ho ng problem when it comes to the quality of inspection done sa Region 4A dahil ho sobrang dami po ng minimum wage rates. I would also like to include that the systems that are overly complex would tend to lose their effectiveness and also may interfere with the existing collective bargaining between the workers and the employers. So, ang sa tingin po namin, the primary purpose po kasi of the minimum wage is just to set the floor wage to protect the vulnerable worker. And not to determine the full wage structure of the labor market. Yun po, Madam Chair. Thank you so much.
Salamat po, ED Criselda. Ah, ah, so, administrative challenge nga, pero the fact na medyo na kuwenta nyo na ilan ang magiging sectors per level, 21 sa first, 98 sa second, 235 sa third. At least na-appreciate ko po, Mr. Chair, na it sounds like sinimula na ng NWPC i-anticipate ano yung implications nung proposal ng industry specific wages. And I would like to ask kasi na sabi po ni ED Criselda na di alam ng NWPC paano kino-contemplate ng UP Law Center ma-implement talaga ito. So at the end of this brief summary of mine to ask a follow-up question, gusto kong tanungin ulit si Attorney Arnie, paano nyo nga ba naisip na i-operationalize ang industry-specific wages? Tapos, interesting na nagkaroon na pala ng in a way experiment, no, piloting sa region 4A, and we should gather and apply the lessons from there. Nabanggit din po ni ED Criselda yung quality of statistics. So, di ko po alam, Mr. Chair, kung nandito ang PSA, and if not, baka pwede pong hingiin ng komite yung comment nila dun sa concern na iyon. If PSA will be able to generate the statistics na pagbabasihan ng industry-specific wages kung sakali, Mr.
The committee
Chair.
secretary is instructed to relay officially to the PSA the request of Senator Hontiveros.
Salamat, Mr. Chair.
I think si
Yes.
Director.
If Mr. Chair, if I may, and
Yes, go
ED,
ahead.
I'll just finish my quick composition of the follow-up question. And lastly po, binanggit din ni ED Criselda na baka yung industry-specific wages would interfere with the CBA processes. So gusto kong tanungin yung feedback ni na Chair Rene and SecGen Ray kung magi-interfere nga po ba sa CBA process ang industry-specific wages. So yes, Mr. Chair, si ED Criselda muna po.
You can comment, and then we ask Attorney De Vera to respond to the question raised by Senator Hontiveros. Go ahead, EDC.
Thank you, Mr. Chair. Yung point ko lang po dun sa concern ko sa UP is because one of the provisions is the creation of industry tripartite boards. So ilang boards yung kailangan nating establish that should determine the wages per industry. Yun lang po, Mr. Chair.
Did I correctly hear you just earlier that you said originally there were 40 rates, which you now brought down to 3?
Region 4.
And that's the region Calabar zone po, Mr.
So maybe
Chair.
that may likewise be a track that from 40 industries you can bring it down to, a smaller grouping. I don't know, no? I'm just thinking off the top of my head. Go ahead, Attorney De Vera.
Thank you, Mr. Chair, and thank you for the questions. One is there is no fixed number. During the discussions, what came out are the existing industrial tripartite councils already in existence. So that's the layer that is going to be used. Is that the final number? No, because this still has to be harmonized. Ang kailangan lang siguro pong linawin na punto dito ay hindi po sinusubok ng bagong sistema na ayusin ang sweldo ng lahat ng empresa. Ang sinusubukan lang po, at we agree wholeheartedly with the NWPC, the concept of a minimum wage is merely to set the minimum, no? That's the minimum. And siguro po engage ko na rin yung sinabi ni Senator Hontiveros earlier, no? Ang thinking kasi po dito sa sa revised labor code, the absolute floor will be the minimum wage, national in scope. It can go higher by industry. You cannot go lower by industry, only higher. For example, banking industry, they should not be tied to a lower rate. No? Yun lang po yung arbitrary example. Can you go higher? Yes. Now by unions. By enterprise, you bargain with your employer higher provisions, higher than their industrial and definitely higher than minimum. Ngayon po idadagdag ko lang dito, no, kaya po siguro kailangan, naintindihan naman kasi po ng UP College of Law na mahirap talaga po yung omnibus. However, I think this is a very good time to look at it as a whole system kasi po, yung pong halimbawa, yung kaninang hindi ko na po masyado napaliwanag, ngayon ko po ipapasok, no? Nilalagay po ngayon nitong revised labor code po yung system ng multi-employer bargaining. It strengthens the ability of workers to bargain with their employers, not just with their employers. Kasi po ngayon, alam naman natin, ang sistema minsan, iba-iba, isang kumpanya pero hiwa-hiwalay yung mga manggagawa dahil iba-iba yung kanilang union. No? Hindi na po ako magbabangkit ng pangalan pero kung kailangan po ng panel, I can give certain examples. No? Under the particular provisions po of the current law muna ngayon, wala po yan sa labor code, yung multi-employer bargaining, pero recognized po yan sa Department Order 40. Okay po yan, pero on a mere voluntary basis. The experts around the table discussing the revised labor code recognized maybe it's time for us to recognize it as a valid form of collective bargaining. Multi-employer because employers are using the business entity in various ways. Maybe it's about high time for the workers to be able to also be as flexible as their employers to talk to their multi-employers in common. Again, this will only build on the minimums, no? Again, national minimum wage, on top of it will be an industrial minimum wage, and then on top of it will be workers dealing with their respective employers, including multi-employer bargaining through collective bargaining agreements po. So, yun po.
Salamat, Mr. Chair. Tas kung pwedeng mahingi yung comment ni Rene, Chair Rene at SecGen Ray dun sa hindi ba makakagulo sa CBA process ang industry-specific wages, Mr. Chair.
Salamat, Madam Chair. Hindi po makakagulo kasi sa halip maayos pa. Kasi kung meron tayong entry level na minimum wage, sa industry kasi iba-iba yan eh. Iba-iba yung rates. Tsaka hindi natin pwedeng i-across the board yung mga trabaho sa per industry. Iba-iba yan. So, kailangan mo ng isang industry standards na wala sa ngayon. No? Industry standards. So, kailangan mo ng tripartite formation to consult stakeholders. Ano ba standards sa restaurants? Ano standards sa bangko? Ano standards sa construction, garments, diba? Pare-pares sa industriya eh. So, iba-ibang standards yan. Diba? Sa garments, anong standards ng mananahe? Diba? Yung cutter, etc. Tapos, dahil may union sila, dapat pa ease of organizing unions, pwede pa sila mag-negotiate higher than those standards sa industriya. So, minimum, entry level, industry standards, pwede pang mag-negotiate conforme sa economic standing ng industry ng mas higher. Kasi collective bargaining agreements naman ay lagpas sa standards dapat. Conforme sa capacity ng industry. So, hindi siya magbabangga, Madam Chair.
Salamat, Mr. Chair.
Sa tingin po namin ay hindi po magiging sagabal yun, Madam Chair. Kasi karanasan na rin ng ibang bansa na, for example, sa ibang bansa may national bargaining, may industry o sectoral bargaining, tapos may enterprise bargaining. Which is, yun nga, dito sa Pilipinas, karamihan ay enterprise or company bargaining. Yung binabanggit nga kanina ni Attorney Arnie. So imagine niyo, for example, kahit sa mismong isang kumpanya, kasi bago po ako naging director din po ako ng Labor Education and Research Network. At for example, isang kumpanya, yung soft drinks na lang na sikat. Imagine niyo, isang kumpanya, 50 union sa buong Pilipinas. At iba-iba yung one. May independent, may makakaliwa, may makakanan. So iba. So imagine niyo kahit mismo sa isang kumpanya at yung mga benepisyo at kadalasan diyan, ang inuuna ng management na i-negotiate yung pinakamahinang union para to follow na lang yung iba. Kahit malakas ka, sasabihin lang nila na kwan. Kaya hindi sa tingin namin hindi magiging problema 'yan. At in correlation din 'yan, yung paniniwala kasi namin, pag mataas din yung kwan, yung density ng mga union katulad sa Nordic countries, hindi nila nagiging hindi wala nga minimum wage sa Nordic countries because dahil sa high density rate ng union through CBA negotiations ginagawa yung kwan. Kami naniniwala sa ganung kwan na dapat kung mapapalakas nga yung mga union at mababawasan yung mga restrictions sa pagbubuo ng union at tumaas yung density, mas hindi lang kami titigil doon na sa collective bargaining agreement, talagang minimum na lang yung kwan. Pangatlo po ay may existing ng mga tripartite industry na create din ng kwan ng Department of Labor. For example, in our case, we have this Automotive Assembly Industrial Tripartite Council. Ganon din po yung sa construction, ganon din po sa garment, ganon din po sa bangko. So all major industries sa ngayon ay meron na hong tripartite. So ito yung pwedeng isang venue para pag-usapan din yung mga issue ng sa wages. Yun lang po, Madam Chair.
Salamat, Mr. Chair. Bukod sa Nordic countries, alin pang ibang mga bansa may ganito ng industry-specific wages? Meron pa po ba?
Sa Asia po, karamihan ng developing countries, for example, Japan is one. Pagkatapos sa Europe po yung karamihan din.
So at least po may isang Asian country na kumbaga nasa neighborhood natin. And then mabuti po na may existing tripartite industries na pala sa at least 4. So hindi tayo magsisimula from scratch at pwede din nating kamigin yung mga leksyon doon para i-consider itong industry-specific wages. Yung huling paksa ko na gustong itanong, Mr. Chair, ay dito sa labor-only contracting. The Secretary of Labor and Employment is explicitly granted the power to issue regulations restricting or prohibiting the contracting out of labor to prevent circumvention of the code. Ano pong specific criteria at parameters ang ipaprioritize ng DOLE para sa wakas gumuhit ng isang hard line sa pagitan ng legitimate job contracting at saka prohibited labor-only contracting, Mr. Chair?
Yusek,
Mr. Chair, may I request the Director Pat? We are amending 174, di ba? Or BLR?
labor only and
We are revisiting Department Order 174, which is currently being discussed on the labor only contracting but in due time we will furnish this honorable committee.
So, Mr. Chair, Yusek, yung pag na-revise nyo na po kung sakali yung DO 74, ito na po yung pagkukunan ng DOLE ng criteria at parameters para i-distinguish yung legitimate job contracting saka prohibited labor-only contracting?
Yes, Your Honor.
And yung in due time, ano pong time frame po pare?
Right now, we are revisiting the department order and we will present it to the NTIPC, National Tripartite Council. And it will answer the right now kasi doon sa ating labor code, mayroon namang provisions doon na inaalaw ang labor contracting. That's why we have these industries. Pero we are revisiting it considering that some of the provisions is not anymore in tune with the appropriate time. Sa ngayon, meron kaming revisit na namin, TWG, everything, para ibigay namin sa INTIPSI for their bidding.
And yung pagpepresenta nito sa National Tripartite Council, by next month po ba or by the end of the next quarter or by the end of the year? Ano po yung tinitignan po nating panahon, Mr. Chair?
Second quarter. According to the representative of the Bureau of Labor Relations, mga second quarter daw, Your Honor.
So by June this year at the latest, Sir Yusek.
Yes, Your Honor.
Salamat, sir. Mr. Chair, I wonder if Attorney Narisma of BLR would like to add anything to this question.
Go ahead.
Mr.
Go
Chair.
ahead, Attorney Narisma.
Good morning. Good morning, Mr. Chair. Our Bureau Director, Director Herbosa, and two other mediator arbiters are now in the process in consulting with our stakeholders and consolidating their comments and inputs. And later on, this will be presented to the NTIPC. And then later on, if this is approved by the tripartite body, we will issue a department order within this year, amending the DO 174.
Within this year, sir, pero sabi nyo kanina by June of this year, i-issue yung bagong DO.
Yung June po, yes ma'am, sa NTIPC po.
So yung within this year is by the next quarter, September, or by end of the year po?
By end of the year po.
So by December
hopefully,
this year.
we can have a new DO on amending DO 174.
December December this year at the latest po.
Yes.
Alright, salamat po, Attorney Narisma. Maraming salamat po,
Thank you.
Mr. Chair. Those are my questions for now.
Okay,
Salamat po.
NLRC. Yes, Commissioner. Go ahead.
Magandang tanghali po mulit. Mabilis lang po na tungkol po rin sa issue ng shift sa judiciary. Kasi po ako po ay bago na appoint na NLRC Commissioner noong 2022. Ako po ay 20 years na practicing lawyer din sa labor. Ako po ay dating SecGen ng pinakamalaking labor federation sa Pilipinas ng Philippine Trade and General Workers Organization. Inabot ko pa po na yung kapanahunan ng mga early 2000s na ang mga cases po sa NLRC ay inaabot ng 2 taon or mahigit sa labor arbiter bago maresolba. Totoo po yung sinabi ni Attorney De Vera na nasa labor code po na within 30 days after the case is submitted for resolution, kailangan po magkaroon ng resolution yung labor arbiter. Nangyayari naman po ito usually sa labor arbitration proceedings after around mga 2.5 to 3 months kasi po meron pong mandatory na 30 days na conciliation mediation conferences, submission ng position papers, reply, rejoinder, etc. Saka po siya magiging submitted for resolution. 9 months po yung inilagay na process cycle time ng NLRC kasi po we are factoring in po yun pong realidad on the ground. Ang cases po na hinahandle ng ating labor arbiters ay nasa average of 27 per month. Assuming na lamang po na kayang mag-settle ng labor arbiter ng mga 4 or 5 cases doon, ang matitira pa po na for resolution ng labor arbiter ay between 20 to 22 cases. Mag-isa lamang pong nagsusulat ng desisyon yung labor arbiter. So ang ibig sabihin po nun, sa isang araw kailangan nakaka-resolve po siya ng isang kaso. Hindi lang naman po pag-resolba ng kaso yung trabaho niya. Araw-araw po siyang nagkakaroon ng hearings kasi yung conciliation mediation conferences, kailangan po personal na labor arbiter po ang ang humaharap doon. Yun pong pinakamalaki pang proseso yung tungkol sa execution, sa labor arbiter din po yun. Kasi po pagka nanalo na yung tao, ang mas mabigat po na portion doon ay yung enforcement ng desisyon. Kung paanong makukuha ng tao yung kanyang napanalunan. Okay? So yun po. Ulitin ko lang po ulit, no? Yun po yung realidad kasi wala pong katulong na abogado yung labor arbiter na magsulat ng desisyon. Yung pong meron siya ay isang labor arbitration associate na hindi po abogado. So sa pagsusulat po ng desisyon, mabilis po talaga na yung 9 months period na yon.
Yung
yes po.
Before you proceed, yung pagdadagdag ng commissioner, no? Meron bang naisabay na pagdadagdag ng mga labor arbiter? I mean, throughout or how does that
Mayroon po yatang mga nadagdag pero paunti-unti po yung nadagdag. Pero just the same po,
Okay, good.
yun pong again yun pong cases nga po kasi sa NLRC is 30,000 per year and on the average it's around 27 to 30 per labor arbiter. Kung halimbawa lamang po nadadalhin po natin doon sa judiciary, napapaloob po rito na number one, yun pong conciliation and mediation ay aabuti ng 60 days. So mas tumatagal po siya. Tapos po dito, hindi po siya submission ng position papers lang. Mayroon po ritong submission of affidavits and meron pong entitlement yung kabilang partido na magkaroon ng direct examination, cross-examination, redirect examination, recross-examination po. So ang nangyayari po sa kanya, although it's summary proceedings, para pa rin po siyang merong trial. And kung sa mga practitioners po na mga abogado rito, kahit po sa MTCs, ibig sabihin sa Metropolitan Trial Courts po, sa judiciary, kahit po meron pong tinatawag na summary proceedings, halimbawa po yung BP22 cases, nare-resolve po yan mga 2-3 taon pinakamabilis na. So kung gagamitin po natin yung proseso po dito, hindi po siya bibilis, lalo po siyang babagal. Kasi po, yung scheduling lamang po ng mga redirect, cross, recross, aabutin po siguro ng mga baka mahigit 1 taon po yan bago po yan matapos. So, hindi po siya bumibilis pag nag-shift po sa judiciary. And ulitin ko lang po ulit, no? Yun pong pagkakaroon po ng apela papunta sa Court of Appeals. Actually, sa totoo lang po, wala po yun sa rules of court eh. Kasi po talaga nga pong ang apela before, although Rule 65 po siya, from NLRC, papunta po talaga siya ng Supreme Court. Pero po, it's a judicial jurisprudence po yung St. Martin funeral case. Kaya po, I don't know po kung pwede pong by legislation ay mapalitan po yun kasi parang naging procedure na po siya ng Supreme Court. Yun po yung ano. And last na lang po.
Yes, please wrap up, no? Because
Yes, sorry po.
we still have another...
Yes po. Pag halimbawa pong tayo ay naglipat sa judiciary, kailangan rin po nating mag-hire ng mga bagong judges to handle all of these 27 to 30 cases per labor arbiter eh. So, ganun din po yung magiging sistema niya. Kung halimbawa pong didiretso po yung desisyon ng ating mga judges based po rito sa Labor Code Revision, kailangan rin po natin mag-hire ng 24 na Court of Appeals Justices para po i-absorb yung 10,000 or so na cases na inaapela mula labor arbiters papunta po ng commission. So yun po yung...
Can you put that in a decision paper so that it is taken into consideration?
Yes po.
Para maliwanag. No?
Yes po. Maraming salamat po, Mr. Chair.
We appreciate your experience, no, and the practice, no, that has given you that how do you call it, knowledge as to how the processes may or may not work. So we need that sa position paper ng NLRC.
Maraming salamat.
You should submit it like your life depended on it.
Sigurado po yun, Mr. Chair.
Salamat.
Maraming salamat po.
Go ahead.
Huling follow-up, Mr. Chair. Very well noted po yung mga points nyo, Commissioner. Kung sakaling i-carry po ng committee report yung shift to the judiciary, ano naman po yung tingin nyo dun sa isang binanggit ni Attorney De Vera na interim period or transition period? Isama na rin po yung alam kong isang concern ng NLRC about survivorship na tatrabahuhin din po namin. Any thoughts on the interim or transition process, Mr. Chair?
Mahirap. Hindi ko po alam kung paano yung interim na sinasabi nila kasi po kung halimbawa pong from quasi-judicial papunta ng judiciary, I don't know po kung halimbawa pong yung in the meantime, yung mga decisions ng mga labor arbiter or i-keep yung labor arbiters para po kasi, syempre, yung volume naman po ng cases, di naman po nababawasan. So, I really don't know po kung paano magkakaroon po ng shift ng papunta sa judiciary. Yun pong sa survivorship naman po, para po sa benefit ng committee, ang pong labor arbiters at ang mga commissioners lamang po ang walang survivorship benefits. Kahit po yung ordinaryong SSS at GSIS pensioner, pag po namatay po yung pensioner, yun pong kanilang mga spouses ay natatransfer po yung pension papunta sa spouse. So, labor arbiters lamang po at commissioners po yung wala nun. Kaya po we're pushing for a law na granting survivorship benefits po sa kanila.
Maraming salamat po, Mr. Chair. And isa na akong miyembro ng komite nyo, looking forward sa participation ng NLRC sa ating technical working group. Salamat po, Mr. Chair, at salamat po.
Thank you. There is a request from the GCG that they have a meeting in Malacanang and that they ask to be excused. You are excused. Actually, all the other resource persons for the measure on the amendment, the labor code revision, you can be excused. We will now proceed with, if you can quietly vacate your seats so that we can continue with the hearing. Thank you very much for your presence. We now proceed with the three measures, Revised Government Auditing Act. The COA has a presentation. Again, Commissioner Malilin, you have the floor. Please proceed.
Good afternoon, Mr. Chair, and good afternoon, Senator Hontiveros. On behalf of the Commission on Appointments, we are thankful that the Commission on Audit and the auditing laws are now the subject of amendments. Considering that Presidential Decree 1445 was enacted in 1978, and on account of the various and significant changes in auditing, finance, governance, and technology, it's high time, Mr. Chair, that the law be made to fit the contemporary time. Now, in the areas there are, we are just going to present the highlights. It's a very massive law, but the highlights would entail the expansion of the jurisdiction of the Commission on Appointments. There is a certain emphasis towards the audit of private entities, public utilities, where we have certain issues on rates, we have issues on certain entities that receive funds from government, which the Commission on Audit is proposing to audit as well. The matter on digital transformation, Mr. Chair, the law is quite old. Technology has come in. We are also overtaken by AI. And we are now taking a look at certain tools that we need in order to further enhance the effectiveness of the Commission on Audit. The matter on fiscal autonomy is also part of the proposal, Mr. Chair, considering that the Commission on Audit is an independent constitutional commission. Therefore, there are certain matters where, in terms of the budget, in terms of the release of the budget, and in the areas of attracting competent, certified public accountants and lawyers and other professions to enable them to join the Commission on Audit. It is quite a marked matter in the Commission on Audit, Mr. Chair, that a lot of our personnel, the moment they are well-trained or we find them very competent, they find greener pastures, even among other GOCCs, considering the exemption of the other GOCCs on the salary standardization. And we would also want the participatory audit, the CPA, we call this a CPA, where we have civil service and NGOs coming into assisting the Commission on Audit. Therefore, we're also taking a look at amending the law to enable the Commission on Audit to have a stricter enforcement of the provisions that we bring out. So therefore, we're looking at stricter penalties. In the meantime, Mr. Chair, that we're taking a look at changing the law. We would also want to manifest and inform the committee that we are also undergoing certain reforms within the Commission on Audit. Considering the past year, where the Commission on Audit, its functions has been emphasized. We're looking into certain technical changes and rules, including geotagging for infrastructure projects, not solely for DPWH, for anything that is infrastructure related. And we are looking into also changing certain processes inside the Commission on Audit. We understand that there is a move for immediate digitalization, but our processes itself, manual or technological, have to also be streamlined. So internally, we are doing this, but everything with focus on delivering the mandate of the Commission on Audit. So considering the limited resources, considering the technological advances, the amendment of Presidential Decree 1445 is quite ripe and in time. That is all, Mr. Chair. Senator Hontiveros.
Thank you.
Thank you very much.
Thank you, Commissioner
Malilin, Mr. Chair.
Malilin.
Malilin.
Kapampangan ba ang Malilin?
Malilin, Mr. Chair. My father hails from Cagayan Valley.
Okay.
There are a lot of Malilins there.
Thank you, Commissioner. We now go to the OSG. Ma'am, do you have your position paper? Go ahead.
Your Honor, in general, we have no objection to the passage of the bill, which seeks to enact a newer and more relevant auditing code. We will be submitting our position paper with comments on certain provisions.
Yes, please. Thank you. Thank you. The OGCC, Attorney Vidal.
Yes, Your Honor. Similarly, Your Honor, we be given the opportunity to submit our comment or position paper with respect to these three bills. Yeah.
Okay, thank you.
Thank you, Mr. Chair.
Thank you. Okay, we can proceed with PICPA. Mr. Cruz, you have the floor.
Thank you for the opportunity, Your Honor. In behalf of the Philippine Institute of Certified Public Accountants, we have around 26,000 active members of CPAs in the 4 areas: public practice, commerce and industry, education, and also government. If given the opportunity, we would also be submitting our position paper with regard to the amendments to the auditing code, Your Honor.
Okay, thank you. Maraming salamat, sir. The PPP. Kayo ang isa sa mga nais masaklaw o kaya masakal. Mailagay sa ilalim ng auditing.
Yes, Mr.
Go ahead.
Chair. Thank you. So, as with the previous Congress, Mr. Chair, when similar bills were filed, we expressed the PPP Center's support for the bill's objective of instituting measures through the promulgation of auditing and accounting rules and regulations. Because, Mr. Chair, the PPP Center recognizes the wisdom behind the audit of PPP projects. In fact, in the previous years, until today, the PPP Center worked with COA in crafting a so-called COA PPP audit manual, recognizing the unique nature of PPPs, which is very different, of course, from the infrastructure and development services that are procured under traditional government procurement, and therefore there are nuances involved in the audit of these PPP projects. So in general, Mr. Chair, we support the assignment of the auditing of PPP projects to the COA's Special Audit Services sector, because auditing of PPP projects requires familiarity of these nuances with PPP practice and specialized knowledge when it comes to PPPs. We do have, Mr. Chair, suggested improvements to the language of the bills to make it more aligned with what is provided for in RA 11966. This is the PPP Code of the Philippines, which was signed on December 2023. So it's recently passed. Meron lang po kami, Mr. Chair, suggested language that we would like to the committee to consider para mapaganda po itong bills po natin, so that when it comes to the PPP projects, we could be able to introduce the reforms properly.
Thank you.
Mr. Chair.
Thank you. We look forward to your submissions. The Bureau of Treasury, sir. Thank you for your patience. I think we are the last resource person.
Good afternoon, Your Honor. Thank you for inviting the Bureau of the Treasury. The Treasury supports the measures to modernize and strengthen the Commission on Audit and the function of auditing government accounts and public officers with accountabilities. Should there be any comments coming from the Treasury, Your Honor, it may be in the nature of seeking clarifications, which is better put in writing considering that it may have technical questions, Your Honor. So we would just send a position paper, Your Honor.
Yes, please. And actually, all these position papers, after we go through them, of course, we will have technical working groups so that we also will be inviting you to these TWGs so that we can thoroughly discuss the finer points of your position papers. Thank you, Mr.
Cadorna, Your Honor.
Cadorna.
Yes, Your Honor. Thank you.
Ma'am, sa DICT, sorry, what happened to Yusek Almirol?
Good afternoon, Mr. Chair.
What is your name, ma'am?
I'm Yesli Corazon Haen po, from the Internal Audit of the ICT.
Okay, go ahead, ma'am.
For the ICT po, we hereby manifest our support for the proposed legislative measures seeking reforms to the state auditing system, especially in the Senate Bill numbers 247, 502, and 868, and expresses endorsement for their immediate passage. Likewise, Mr. Chair, the ICT commits to extend the requisite technical, advisory, and infrastructure support necessary to give full effect to the digital components contemplated under the proposed measures. If I may add, Mr. Chair, that the ICT is currently working with COA for the transparency under the blockchain and the interoperability to promote, again, the transparency of our budget system.
Yes, thank you. Okay. Dito po sa COA, may we request, as you present the position paper, perhaps a separate, how do you call it, set of recommendations on the basis of, for crafting the legislation, on the basis of the lessons that you have drawn from the flood control scam. No? I think something like that should never, ever, ever, ever happen again. I guess we all agree. Apart from, of course, punishing the guilty, which is one way of ensuring that it sends the strong signal that this should not happen again, is, of course, the provisions, the auditing processes that are put in place that would either be, preventive of clearly a lot of gaps. We saw a lot of gaps in the flood control scandal that has to be addressed by way of precisely in legislation such as this one, proposed legislation, and of course, as an autonomous, independent constitutional body, your own resolutions and your own recommendations. So I'd like to have that as we work towards precisely finalizing the committee report and the measures and the provisions of the new auditing code. We're also looking at interesting, how do we put into the code a more transparent process by way of citizens audit and participation? If I understand it correctly, it is not yet a law. It is merely, I think, a COA resolution plus an executive order, among others. No, so we'd like to make that ironclad by making it part of the code. That would help. Um, Maybe also the aspect of the um, well, the DBM in coordination with the COA, no, in terms of yung uh, integration of yung corporate budgets. Tama ba yun? Yeah, yeah. Yung for example, how will yung DBM approve corporate operating budgets? How will it be treated under the amended auditing code, di ba? Mga maybe you can off the top of your head, Commissioner, baka meron kayong comment doon.
Thank you, Mr. Chair. Mr. Chair, the COB is normally course through also the GCG and the DBM.
Yes.
So COA comes into play the moment these budgets are implemented or operationalized. COA comes into play when they start taking a look at spending these budgets.
Yes, yes.
But taking a look at the reasonability of the budgets, it's a play between DBM and GCG, Mr. Chair.
And it's just toward the auditing of how the budgets were utilized.
Yes, Mr. Chair.
Again, because the code is 50 years old, we need to put emphasis on the digitalization of the provisions. No, I mean provisions on digitalization rather should be clear. Offhand, Commissioner, are you at liberty to share with us some of your thoughts on how the code should now incorporate digitalization?
Mr. Chair, our approach to digitalization is we are now taking a look at all the processes because coming from the Commission on Audit is the Government Accounting Manual. Now, the Government Accounting Manual by itself is also quite antiquated. There is a temptation to immediately jump into automating the process, but if we don't even streamline the process itself, the automation is just a matter of we're putting a very old process and enforcing a digital stream to it. But it's now going to be a twofold approach or a strategy. We streamline all the processes, and this affects GOCCs, LGUs, and national government agencies. Then we're also, from there, we're taking a look at even overhauling whatever accounting information systems we have. Now, based on that approach, so the digitalization approach, then we're putting in all the security features. The DICT has made mention of making everything transparent. Therefore, we're not just going to wait for the year end for their annual audited financials. There may come a point in time where we do remote audit. We don't even have to go physically to the office. We do, there is a vision to even take a look at the transactions on near real time. So it's not after a year that we take a look at it. If the digitalization or the information is captured near real time, even the Commission on Audit will have visibility of the transaction from a central point of view. So with all of this, Mr. Chair, that is the focus of the digitalization. For your information, Mr. Chair, we are also working with certain international financial institutions, the World Bank and the Asian Development Bank, under the program of the Public Financial Management Systems, which is also in coordination with the Department of Finance and the Department of Budget and Management. So the shift to digitalization is in close coordination with the two principal finance institutions of the executive, the DBM and the DOF also, Mr. Chair.
Well, going back to the flood control issue, no, and the budgetary process. Um, I'm just thinking out loud, no? Because what we did in the 2026 budget process, we opened it up. We made it live streamed. We made sure that wala na itong closed door sessions. So these are our efforts to create transparency. Now I'm thinking, um, I know it's separation of powers. We have the power of the purse. You are in the executive department or independent constitutional body. But moving forward, if, for example, the COA has some role, or has a observer status, I don't know, in the budget process. Uh, I don't know how that will be, could that be placed in the auditing code? I don't know. No, you don't have to have the answer now, no, but it's something to think about. Because sabi nga nila, insanity is doing the same thing over and over. Si Einstein nagsabi nun, di ba? And expecting a different result. So as we open up the process, as we did open up the process of the budget deliberations, we're open to looking at what other interventions we'd like to see. I'd like to see a greater transparency. Initially, we did have observers from the private sector. We did engage the services and collaborated with civil society groups. No? So now I'm looking at, okay, should COA have some presence in the budgetary process? I don't know. I have no answer now. I'm just thinking about it, because if we are able to give civil society organizations some role in the budget process to make it more transparent and more and greater accountability, what about the COA? Diba? I don't know. I don't have the answers, but maybe you can think about it and come up with some recommendations, if at all. No, I know it's we're jealous of our powers, but at the same time, how do we make sure that jealousy is not because we want to protect interests that are illegal, as we have seen in the past. No, but anyway, I'm just thinking out loud here. I hope you understand. But I'd like to see how we can strengthen COA in as regards ito na nga, being able to learn from the lessons of this fiasco, the biggest corruption scandal in the history of the country. If we don't learn from this, I mean, napakawalang kwenta naman natin sa larangan ng public service. But anyway, dun sa issue ng private-public partnerships, what prevents the COA at this point from going into the PPP transactions, knowing fully well that government funding is made, diba, is involved? Sorry, forgive my ignorance, but go ahead.
Mr. Chair, on the matter of the PPP, public-private partnership, the opposition to COA auditing this is a private entity. They invested their funds into the matter. Government comes into play, and depending on what modality, whether it's a build, operate, transfer, build, operate, own, this was initially seen as a totally private venture. And that has been the main or the principal ground for COA not entering, or COA being prohibited from taking a look at it. However, Mr. Chair, auditing is usually, people are normally familiar with auditing in two matters, which is the financial audit and the compliance audit. On matters of financial audit, that's when we bring out our audit opinions. On the matter of compliance audit, we take a look at if the agency has actually complied with certain laws, like the procurement law in acquiring. But Mr. Chair, COA also has a third function, which is the performance audit, where we check whether the objectives of the program or the project have been met. Now, under a PPP scenario, we have the private entity, yes, having gone into, let's say, an unsolicited proposal, having implemented the project. The part of the audit, even if we take out the compliance or the financial audit, can now focus on the performance audit. What was promised? Was it delivered? Was it at the standard that the representations made to the PPP center, were they in fact fulfilled? Or were we may not even take a look at were the rates reasonable, because the point in the PPP would normally be the delivery of a service which should have initially been invested upon by government, but this time it's a private entity. And if I may, Mr. Chair, going back to your first question, well, constitutionally, the Commission on Audit is on the audit side, or the accounting side of things, where the operations have already been implemented. But maybe on the matter of a point of participation, or we could say a point of contribution, would be, which we always do with Congress and the Senate, Mr. Chair, is if the focus is a performance-based audit, which is now results-based, which a lot of international jurisdictions have already started implementing, considering that if the digitalization is actually implemented, so the financial and the compliance would take care of that side. But if the focus is performance, where if a certain agency requests for a certain budget, and that budget is actually provided the agency, the matter of audit would now focus on were they able to deliver as committed, and that's the reason why they were given the budget. Maybe that is where the Commission on Audit can assist Congress, the Senate, in taking a look at how effective the project was delivered. Thank you, Mr. Chair.
Yes, thank you. Now it got me thinking, because, for example, the Customs Modernization Act, di ba? Modernization, di ba? And Tariff Act, which requires the 90 days from the passage of the law, requires the single window operations, no? Sa awa ng Diyos, wala pa. And it's been what? 6 years? How many years? I'm not sure anymore. Yeah, so they say it's failed bidding, etc. But still, no? Nasa DICT ba? Oh, yeah. Now, parang nagkaroon ng panibagong going around the failed bidding and the effort to implement the law, di ba? And operationalize the single window mandate. Would you care to comment, ma'am?
Yes, Mr. Chair, it's with the ICT, and actually we're now pushing with the right now with Yusek Almerol that we are pushing with a single window policy, so that all agencies will be connected in one system, and then the transaction would be more transparent and easier and more streamlined. This is now po working na. We are working fast for this operations po.
Well, okay, sige. Medyo ipit na tayo sa oras, no? The GCG. Oh, you're back. Oh, you're still here. Go ahead, ma'am. Attorney
Alviola po,
Yes,
Mr.
yes.
Chair.
Oh.
Good afternoon. On behalf of the Governance Commission, we would like to thank the Honorable Committee for the invitation. We also attended the committee meetings and technical working groups last Congress, Mr. Chair.
Okay, go ahead.
Yes.
Go ahead, please.
Okay, we have filed.
So you have institutional memory. Go ahead, please.
We would like to manifest, Mr. Chair, that we already have filed our
Hi,
position
I'm
paper
Emmanuel
on this
Hagatianza,
measure.
but everyone
But
just
may
calls
I
me
be allowed to
Eman.
read
I
from
think I'm
my-
known on
okay.
social media
Go
for
ahead.
being an English
Okay.
era.
The
I
Governance
pride myself
Commission
on being
expresses its full
authentic
support for
and
the modernization of the
posting
government
what I feel
auditing
like is
code.
true to me.
The proposed
Before I
shift
didn't
toward
understand anything
digital
at all.
transformation,
I couldn't
fiscal
speak anything,
decentralization,
couldn't understand a
and the
word except for
adoption of
maybe like
international public sector
kamusta and
accounting standards
po
is both
and
timely and
ate
necessary.
kuya.
By way of
I'm really passionate
background,
about
the
mental health.
Governance
I've wanted to take
Commission, in line
psychology
with its
since I was
mandate
very,
under
very young
Republic Act number
because I noticed the
1149,
lack of mental health
previously
resources in the
submitted its
Philippines.
recommendations
Ever
and
since then, it's
similar
always kind of
measures to the
inspired
Honorable
me
Committee during the 19th
to
Congress.
pursue this
The
industry.
Evan, can you
Governance
tell
Commission
us
notes
something
with
about your family?
appreciation
I'm
that
very
SB
grateful
Senate
that
Bill
they
numbers
worked so hard to
247
give me
and
the life that I
868
have.
have
I got to
adopted the
get a
recommendations
lot
of
closer
the
to them in the
Commission.
past couple years. I have an older brother and an older
So the
sister. I'm the
first one,
bunso. Once
Mr.
they went
Chair,
off to
was a
college, we got a
definition of
lot
the
closer.
What
government-owned
would make you an
party-owned
interesting housemate,
corporations. So we
Emma?
have noted that this has been changed
I
already
think
under the
one
two
thing that could
proposed
be
measures.
really
Also,
funny is just
on
that
the
I can't
disposition
speak
of assets and
Tagalog.
declaration of
I think I'm
dividends,
also a very
there is
extroverted person.
already
I love to make friends with
uh,
people. I talk to
preparation
people
on this in terms of
just for the fun of it. Anyone who
the
knows me
permission
personally
from the
knows how
Secretary of
outgoing I
Finance
am. And
in case
I think
that
being
there's a
placed in that kind of
declaration of
environment would
property
also
dividend. In another note,
help me
Mr. Chair,
thrive,
aside from
hopefully.
noticing that
Hi, I'm
our
Emmanuel
recommendations
Huggins.
have been adopted already, the Governance Commission proposes harmonization of the power to compromise claims um, in the context of our mandate under Republic Act number 10149. So we would like to expound on this. The Governance Commission expresses its full support for the amendments under Senate Bill numbers 247, 502, and 868, which propose updating the threshold for the Commission audit's power to compromise claims up to 10 million pesos now. This adjustment is a timely recognition of the impact of over 4 decades of inflation and the evolving operational realities of modern governance.
How much is it
Building-
now? How much is it?
10 million na po ngayon, Mr. Chair. So, it used to be 10,000 if I'm not mistaken. Yeah. So, medyo, opo. Yeah, building upon this modernization, the Governance Commission respectfully proposes that the revised Government Auditing Act explicitly recognize a limited authority for the Governance Commission to exercise this power also during the corporate abolition process. This alignment is essential to ensure the orderly reorganization and liquidation of GOCCs as mandated by RA number 10149. Accordingly, in addition to the previously proposed amendments, we recommend a new amendment to harmonize the powers ni GCG and ni COA. So it's either Section 34 or 36 in the Senate bills. We would like to add a proviso which reads that provided further that in the implementation of the abolition of chartered and non-chartered GOCCs pursuant to Republic Act number 10149, the Governance Commission for GOCCs shall have the authority to condone, compromise, or release in whole or in part any settled claim or liability of an abolished GOCC. So nakalimit lang po siya dun sa GOCCs under abolition in an amount not exceeding yung threshold po natin na 10 million pesos subject to the review and post-audit po ni COA. Provided finally that the exercise of this power shall be strictly limited to the following instances. Number one, to facilitate the final liquidation and formal closure of the GOCC where the cost of further litigation or collection effort is estimated to exceed the recoverable amount. Second, to prevent the further accumulation of interest, penalties, and storage or maintenance costs that would otherwise diminish the remaining assets po ni GOCC. Or number three, to resolve dormant or uncollectible accounts that have remained in the books for at least 10 years despite the exhaustion of all reasonable legal and administrative remedies. In case the claim or liability in such abolition cases exceeds 10 million, the GCG shall submit the application for relief along with its recommendations directly to the Commission on audit for appropriate action. And Mr. Chair, for my closing, this proposal is based on the Governance Commission's extensive experience in overseeing the liquidation of non-performing and or unnecessary GOCCs. In that note, Mr. Chair, that ends our comments and suggestions. I hope the COA can work on it, but we defer to the wisdom of the Congress, Your Honor.
Yes,
Thank you.
thank you. I understand you've submitted it already, no? So we will take that into consideration. Maraming salamat, Attorney Alviola. On another note, we do have a meeting that we had to postpone with the GCG regarding NAPCOR because there is I think a 2-hectare facility in Agusan Sur that there is a warehouse that the LG or the provincial government wishes to use, but it's tied up in liquidation and. But I said, in the meantime, they're not able to use it. So what is, parang, instead of, the meeting was meant to be an opportunity to find out. So, in so many words, I was going to say, don't tell me why we can't use it. Tell me how we can use it. Parang yung DBM dati, di ba? Senator, hindi pwede yan eh. Hindi pwede. Sabi ko, lahat hindi pwede eh. Baka pwede nyo sabihin sa akin, ano yung pwede? Dito sa usapin na ito, para ma-release yung pondo, para magamit yung facility, etc. But we will resolve that in another meeting. I have no other questions and I think we can suspend, no? Yeah. We'd like to thank our resource persons for your patience. We've been here since 10 o'clock. But I always remind my team that we're doing this because we serve at the pleasure of our people, and therefore it's a small sacrifice compared to what our people have to go through every day. And thank you for your sacrifice. Maraming salamat that this meeting or this hearing of the Committee on Constitutional Amendments and Revision of Codes is hereby suspended.
Recording stopped.